I'm happy that they have shared their valuable time with us to discuss these issues with us and enlighten my students from Bennett University. It's a great pleasure. I welcome Ms. Sarah Hussain from Bangladesh. I welcome Vrinda Grover from our Supreme Court of India. And I also welcome Mr. Salman Raja, the Senior Advocate of Supreme Court of Pakistan. I welcome Ms. Tyagi Ruwampati Rana from Sri Lanka. And I welcome our own Vice Chancellor, Raghunath K. Shivgankar. He's a very fine academician, inventor, and technician, thinker, teacher. He was former director of the IIT Delhi. He was former Vice Chancellor of Pune University, and we are fortunate to have him here. And he is the author of a book on fiber optic communication. He's a specialist in computational electromagnetics. He wrote a book on that. He wrote several research articles, around 170 in national and international journals. I would like to request Professor Raghunath Shivgankar. He is also a musician. He's a poet. He's a painter. I'm happy to introduce him and have him here. And I request him to inaugurate. Before that, I also welcome all other guests, Mr. Shailesh Gandhi, Venkatesh, and my own students, my own colleagues, and all other friends who joined today in this webinar from different parts of the world. Sanjay Hajarika ji, sorry I missed it. You're most welcome, sir. You're a very important person, media personality, author, writer, journalist, filmmaker. You're welcome, sir. Thank you so much for joining us. Now I request...
thank you, Professor, for those welcome remarks. It's an honor for CHRI, the Commonwealth Human Rights Initiative, which works in the areas of access to information, access to justice, and now increasingly on freedom of information and international advocacy around all of these, to do this webinar in partnership with Bennett University. And we are very grateful to the Vice Chancellor, Professor Shivgankar, distinguished academic and inventor, for agreeing to open the webinar. And I hope that it will be the start of a long and fruitful relationship with Bennett University, because as somebody who worked in a university for 10 years and taught and researched, etc., a university is for students. And I hope that through the work we do on issues of rights, that we can be involved or associated with courses that handle some of these issues, that look at some of these issues at the law centers and so on. But also we'd like to offer internships to some of your students who may wish to intern with us in our internship program in the summer or winter. While welcoming all the distinguished panelists joining you in that and who are leaders in their own rights, I wonder if maybe Sarah can tell us if Dr. Kamal Hussain has also joined us.
I'm not seeing him on the line yet, actually.
Okay, I hope that he will be joining us, and if he does, I'll just give a word of introduction. He is one of the founders of Bangladesh, a very distinguished barrister, a former foreign minister of his country, and a leading political figure, and Sarah Hussain's father. So one distinguished barrister and another runs in the family. But I'd like to thank you, Professor Acharya, for making this possible. For Venkatesh Nayak of my team, who steadfastly, stuck to enabling this process and working with you and your team to make it happen. So thank you, and I'm handing it back to you.
Thank you very much, Mr. Sanjay Hajarika, for joining me in welcoming our friends on behalf of CHRI, who is co-sponsoring and co-organizing this webinar. Thank you very much, sir. Now, I request the Vice Chancellor of Bennett University, the former Director of Delhi IIT, Professor R.K. Shivgankar, to inaugurate this webinar and say a few words. Thank you, sir. Welcome.
Thank you, Sridhar. Good afternoon, everyone. At the outset, let me welcome on behalf of Bennett University to all the distinguished panelists from different countries, South Asian countries, Bangladesh, Sri Lanka, Pakistan, and of course, our own advocates from India. Bennett University, the law department or the law school has been a very vibrant school. And this BULX Convo series is one of the distinguished series which the school hosts. And there are many distinguished speakers have come in this series over the last 2 years, I have seen. This time, this series has been organized jointly with Bennett University and Commonwealth Human Rights Initiatives. So we are really delighted to have this partnership. The topic which is chosen also is very, very apt at this point of time. Well, there is no doubt that in last 2 months in India, after the lockdown started, the life is completely changed. And we don't know whether this life is changed only temporarily or if it is going to be restored, what is the timeline for the restoration? It may be a few months, it may be a few years, but when we talk to about technologists and who work in biotechnology, they just don't have any idea how much time this is going to take. So it has become very clear that the information and communication technology is going to play a very, very important role to keep our dialogues on and to have our discussions on. One of the biggest challenges with the Bennett University faced was how to conclude our semester, which was running, and in the middle of the semester, the lockdown started. Immediately, as like many universities, we also switched to the online classes. And I must tell you that all the faculty and the students cooperated very well. We could complete our semester, and we are going to conduct our examinations also online, and hopefully this semester will be concluded. So the technology certainly is going to play a very, very big role, right, in the time to come. Of course, while doing this, we have been using the platforms which are the technology platforms like Zoom or the Microsoft Time or many other platforms. And it's not very clear that when we are using these technologies which are coming from various countries, what are the privacy issues involved into this? And I just want to highlight because it's a legal discussion and many of the legal issues will come when we talk about even technology. Even otherwise, even before COVID-19, in the era of internet and ICT technology, the privacy was becoming really a big issue. Now today, when everything which we discuss, right from our defense discussions to the educational or the classroom discussions, we are using these platforms which are shared by the international people. So it's not very clear what are the legal implications of this, right? How the privacy is going to be protected, and how we are going to handle this as the time moves. In addition to that, of course, the technology is going to pose a bigger challenge. That is, do we have a capacity to really hold this kind of conferences and classes if everybody starts using this medium, right, till we really become comfortable coming face to face and the social distancing has been taken away. Well, there are many legal questions and the common men's question which come in mind, and I just put myself into a common men's category because I'm not from a law side. A simple thing which comes to my mind is what happens to the personal independence, when we are in this and when there are regulations and laws which are imposed by the government. Should the region or religion or my privacy or my personal choices should be superseded by the diktat which are given, or where is the place for the personal rights involved into that? And Human Rights Association probably is better equipped to really make comments and suggestions on that, how to really handle this situation. Of course, when we come to economy and our life in COVID-19, there is always a debate. What US did was right or what India did was right. India actually put the health and the life on priority, though the economy actually got backseat, and we are seeing the implications of that in last 2 months. In the United States, on the other hand, they put the economy on the top, and they just said, okay, fine, we'll handle the situation when it comes. We don't know who is right. As I said, we want Jahan bhi, Jaan bhi. Right? So the time will tell. But one thing is very clear, that as the things are moving, right, I think India probably is one of the best placed countries in COVID-19. Only yesterday's management seminar, when we were discussing the numbers which were quoted, Dr. Kaushik Basu was quoting the numbers, and he said, don't go by the absolute number which the India has. Go by the per million numbers. And he was quoting in the United States, the number are about 200 and odd per million. In Europe or Italy, the number has to be about 90 or something. In India, the number seems to be only 2 per million. So if you really see the percentage wise, I think India has handled COVID-19 very, very well. And I think government's role has been extremely important, right, in handling this situation. Question again comes is that when we don't know what the scenario is going to be, where there are many, many uncertainties which are involved into the model which is going to evolve. And most of the time, the humans are going to interact now with the machines. Looks like, to tell you, hardly any time when you will have one-to-one face-to-face discussion. So you will interact with machine, the machine will interact with another human being and bring the things back to you. So maybe in this scenario, maybe the law will change. The way law looks at the things, that will change. Will there be a new paradigm of the society evolve through this? We don't know. Maybe there is a new, completely different kind of society which will develop in this. Will the lifestyle be changed permanently, right? Because of this COVID-19, there are the pandemics had come in the past also, and people have handled that very well. But this pandemic had really created a very, very large impact on the normal social life, and we still are very uncertain about how the things are going to move, right, as the things evolve. One thing is very, very good, that there is always a good things in every bad thing. So I would say the reduction in travel, maybe it is a good thing for the society. Maybe a lot of people are unnecessarily traveling here and there, and there are a lot of expenditure which used to take place, and a lot of natural resources were consumed by people. So there will be less cultural exchange, physical cultural exchange, if the travel is reduced, but there will be less pollution also, because the travel is reduced. There will be less diseases also, because there are many diseases which were there purely because of pollution. More societal connect will take place with the families. People were just going away from the families. Maybe people will come back to the families now. And so as a whole, there is a good possibility that the new value system might get redefined, right, in this whole process. And that may be something which is worth looking into, because in last 20, 30 years, I think our value system has really gone topsy-turvy. So I think we should really, this might be something good might happen through this, that we may restore our value system, right, and we can have better ecology, right, as the time moves. One thing is very good, that humans have a great characteristic, great property, and that is adaptability. No matter how good or bad situation arises, human beings have adapted themselves in the past also, and I'm sure they will do that during this pandemic also. So with this, I will just thank you very much, and again would like to welcome and thank all the distinguished speakers who have come from India and abroad in this very special lecture series organized by the Law School of Bennett University. Thank you very much.
Thank you very much, Professor and Vice Chancellor of Bennett University, for giving this inaugural address, and you have raised very pertinent points. Yes, your point initially highlighted is what is the situation of human rights, and that is what is the reason for this webinar. Though we are not focusing on the impact of COVID-19 on economy and other general human life, we are trying to discuss the issues that are emanated because of this lockdown followed by COVID on the human rights activity and the general governance, constitutional governance in this country. And how is that people are having access, whether access to justice is reduced, enhanced, or supplemented, or are there any alternative available sources for accessing justice? So this is our focus area. I hope it will also bring out certain new issues of values which you have suggested. What is the value of judicial system? What is the value of adjudication process? What are the new values of technology used in access to justice? I hope your points will be considered on these aspects, and we can go ahead with the discussion with this. I thank you once again for introducing the activities of Bennett University. I would like to tell here that Bennett University Law School has coined an expression, Lex Convo, that is legal conferences pertaining to Bennett University. And we are organizing several seminars, webinars, and interactive sessions, calling experts onto the university platform and asking them to discuss with the students about the practical aspects of justice system. So thank you very much, Professor, once again. Now I'd like to initiate the discussion by introducing our panelists. The panelists are listed according to alphabetical order, and now we have 4 panelists and 2 persons from CHRI and several guests like Mr. Shailesh Gandhi, the former Central Information Commissioner, who is advocating on speedy justice and of course right to information. So we have the renowned personalities, eminent advocates. First, I'd like to introduce and invite Ms. Sara Hussain. She is a barrister practicing at the Supreme Court of Bangladesh, and she is dealing with very important issues of constitutional law, family law, and public interest law. She is serving pro bono at Bangladesh Legal Aid and Services Trust, which has an interesting abbreviation. It's called BLAST. Okay. Then it provides legal services, advice, mediation, litigation, and so on and so forth, and also on public interest litigation on these issues of criminal law, family law, land laws, labor laws, etc. She's more into protection of fundamental rights, and her research of area and advocacy is against discrimination, and she was also trying to develop alternatives to and advocating for removing the barriers to access to justice. Madam, it's a pleasure to have you. Please focus on the issues which are generally affected by COVID-19 situation. We have narrowed down to 3 major broad concepts of our webinar today. That is of what exactly is the general impact of COVID on access to justice delivery systems, and whether the human rights breaches or violations which are peculiar to each country are effectively tackled, and whether these measures are technological additions or solutions which are practiced are within the sphere of due process. So, because these are all the general doubts the students and the law scholars have. So I request you to present your ideas, experiences, etc. Thank you, madam. Welcome.
Thank you so much, Professor Acharya. I'll just start with some comments about the situation in Bangladesh at the moment. We have about 20,000 cases confirmed, about 3,000 people reportedly recovered, and almost 300 deaths. These are the official government figures. There are obviously concerns about whether they are accurate or not, given that we have very, very low levels of testing still ongoing. In our situation, we have a lockdown situation, but it's called a public holiday, and that has been in place since the 24th of March. There has been some relaxation in recent days, with shops being allowed to open in the run-up to Eid, which is in a few days' time. We've also had lockdowns not only across the country, but particularly in the Rohingya camps, where almost 1 million Rohingya are living. There's been no official emergency declared, but the lockdown effectively is resulting in a kind of emergency situation. The legal framework is interesting, I think, to consider at the beginning, that we have relatively new legislation from 2018, the Communicable Diseases Prevention, Control and Eradication Act, which actually gives powers to the government to control any infectious disease, to enforce isolation, and to make relevant rules. But interestingly, this law isn't generally being applied, it seems. There have been a couple of notifications, government orders, notifying COVID as a communicable disease, no action taken under the Disaster Management Act, which could be applied in this context. And there's also been some notifications regarding the requirement to maintain social distance and providing that non-compliance will result in a punishment of 3 months imprisonment or a 50,000 taka fine. There are no limitations on any of the powers that have been given of arrest under here. The Mobile Courts Act has also been expanded to allow summary trial of any offences under the 2018 Communicable Diseases Act. Executive magistrates can criminalize any act which is likely to spread infectious disease or result in disobedience to the quarantine rules. So that's the kind of framework we're operating under. In terms of the formal, and obviously in terms of the lockdown, the two critical, I think the critical issues are what was already identified by the Vice Chancellor as the tension between the lockdown and the livelihood issue. Bangladesh is highly dependent on two areas of for our economy, on the remittances from migrant workers, and of course on the income generated from the ready-made garments industry, which is under almost total shutdown. A few factories have been opening in recent days, but since March they've been under shutdown. We've had 3 billion of orders cancelled from around the world. Migrant workers are being sent home from all of the countries in the Middle East and Southeast Asia where they live and worked. So that has created a major crisis. There has been a government stimulus package. I won't discuss that now. Perhaps questions will come up. In terms of the justice system, now our courts were not, magistrates' courts were continuing to function at a very limited level throughout this period, but our Supreme Court had also gone under the public holiday system. So until a few days ago, we had nothing operating in the Supreme Court, no benches at all. A virtual court has now been declared. A presidential ordinance was passed last week, and a virtual court is now in operation with only very few benches operating in the Supreme Court itself, and the magistracy functioning and being permitted to deal with bail applications. So we have a very, very limited capacity to protect fundamental rights at the moment. Despite that, there have been executive orders dealing with issues to do with, for example, prisoner release. So a number of prisoners, we have very severe overcrowding in our prisons. We have about 68 jails across the country with more than 90,000 prisoners, about 3 times the capacity, more than three times the capacity. So there have been some orders directing that prisoners who are convicted in petty offences may be released. And there's been quite constructive support from NGOs working on legal services with the government on facilitating the release of prisoners. There's also been an order, even during the lockdown period before the virtual court started working, from the Child Rights Committee of the Supreme Court, which directed that action should be taken to release children from correctional centres. But that also requires, again, bail orders to be passed and necessary judicial intervention. Some of that, we hope, will start now. In the initial weeks, the National Human Rights Commission was also not functioning. Now it started receiving email complaints. The most functional aspect, with this transition post-COVID, as much as we can, from in-person responses to online and electronic responses, the government hotlines for reporting complaints, for reporting incidents of violence against women, and for reporting any crimes are actively working. NGOs also operate hotlines like BLAST and BRAC and others, and those hotlines we're trying to expand as fast as possible. There are some limitations and problems with that in terms of requiring permissions to operate hotlines, and we're trying to work with telecommunications companies to facilitate that as much as possible, but there are some issues. In terms of human rights violations, the big crackdown we see, apart from the crackdowns apart from obviously the restrictions on movement, assembly, and so on, in terms of freedom of expression. So we've seen arrests ongoing, particularly under the Digital Security Act. It's very draconian legislation, which had been much criticized, has been challenged, is under challenge in the courts. We've seen a worker, for example, arrested for criticizing layoffs on Facebook. We've seen doctors suspended from work, issued with show cause notices for making, again, Facebook posts criticizing the limits on PPE, the limited availability of PPE. We've seen directives coming out from the sections of the health ministry telling nurses and midwives that they should not share their views in public without prior authorization. Some of the most serious cases, and we've also seen directives. It was a very interesting example of a kind of very strong pushback from civil society, which actually had a positive impact, where the Ministry of Information asked officials to monitor private television channels and social media to see if they were putting out rumors and misinformation, to shut them down if required. But following widespread protests on this, that was actually revised and told that, and we were told that the cell was only going to monitor rumors and not actually take action to shut people down. Perhaps the case which has received the most the most public attention is what we might call the Facebook 11, this case against 11 people, cartoonists, writers, and a Dhaka Security Exchange official, as well as several journalists who live and work and bloggers who live and work abroad, under the Digital Security Act for a quite extraordinary set of charges, accusing them of spreading propaganda and campaigning against the father of the nation, the national anthem, the national flag, the liberation war, tarnishing the image of the nation, and spreading rumors against coronavirus. Two of these people were reportedly secretly detained for 2 days before they were produced in court. 4 of them are currently under arrest. The other 7 face the threat of arrest, and there are unnamed others who have also been named in the case. So just finally, to conclude, another particular concern is around the situation in the Rohingya camps, where there's still an internet ban operating, which means that this transition to electronic operations is very severely hampered. There's been an outbreak reported in the last 2 days in the camps of a corona outbreak, with one of the camps being put under total lockdown. And of course, the entire district is already under total lockdown as well. So in this situation, I think for us as lawyers and as justice providers working with organizations, some of the important challenges for us are how do we move effectively to providing tech solutions, given that so many of our clients don't necessarily have access, can't find out how to communicate with us. We are being able to do it to a limited degree. We're even being able to conduct some mediations and family matters through telephone calls to either party, and not through a multiple platform like this, but through one-to-one access. We're using online platforms to conduct advocacy campaigns, for example, pressing the police to start accepting electronic complaints. We'd asked for the virtual courts along with many others, and very, very delighted that those have come into being finally. We're also really concerned, though, about some of the consequences, particularly with this high levels of surveillance, with this approach that dissent, or not more than dissent, any kind of criticism is not considered constructive, is considered destructive, is considered inimical and hostile. And that's a very difficult context also for us to operate in, and it makes life unnecessarily challenging. I think we're very interested in hearing from others about how the fundamental rights cases are proceeding in the virtual courts, because as I said, we've just opened up very recently and have yet really to start using that avenue effectively in terms of responding to the corona situation and also responding more widely to the other ongoing concerns that we face. But I think that one of our worries is that with the tech platform being, with tech rather than in-person communications being our main source of securing justice in the formal system, many of the issues that we saw as a serious problem ongoing always pre-COVID, prisoners not being, arrestees not being produced before the magistrate, for example, lawyers not having access to their clients to be able to speak to them, limited access in prisons, not only for us, but of course for families, which is completely shut down now. All of those issues we see as being exacerbated, and we need to therefore find ways to open up the spaces for freedom of expression, information, and communication, which are much more urgently needed now, even more than they were previously. I think I'll stop my remarks there. Thank you very much.
Thank you very much, Sara Hossainji, for your graphic presentation of the situation in Bangladesh. Very interesting. I'm happy that email complaints are being accepted. It's wonderful. I don't know, we have to check up whether it is the situation elsewhere. Now it's my pleasure to invite Ms. Vrinda Gover, a vibrant advocate, researcher, human rights activist. She is based in New Delhi. She is a Delhi University graduate. She did masters from New York University, the School of Law. And then she is responsible, or I can say she is the reason and for the wonderful campaign against the sexual violence against women. And then her campaign, her research, her activity, advocacy led to the reforms in criminal law, especially the Criminal Amendment Act 2013. She is a specialist in constitutional law, criminal law, and human rights act jurisprudence. And she did research and advocacy in avoiding the problems arising out of communal conflict. And she fought against extrajudicial executions and the problem of defending the human rights defenders is a very important thing. She's with those personalities who are fighting for human rights. She also was conferred an honorary degree by SOAS University of London. So very happy to have you, madam. Thank you very much for being with us. I request you to make a presentation on situation in our country.
Thank you, Professor Sridhar, and Bennett University and CHRI for initiating this regional conversation. I could see many echoes in what I heard from Sara just now of what is happening in India. And as always, we find that states are able to mimic each other's patterns very swiftly, which makes a good cause for us to have a regional collaboration to be able to take forward the human rights concerns that we share across South Asia. I think as we've just heard for Bangladesh, in India we know that around 25th March, quite suddenly a complete lockdown was imposed by an announcement by the Prime Minister. Alongside Parliament was adjourned sine die, and since then, therefore, mainly the rule has been through executive decree. The legal architecture is through the Epidemic Diseases Act of 1897, to which recently some ordinances have amended, and the National Disaster Management Act of 2005, under which a slew of notifications have been passed, which is the formal legal architecture within which the state is operating. What I would like to focus today on is how it is impacting on, when we talk about access to justice, I will draw a distinction between access to the legal system and access to justice. And I will focus more prominently on how the Supreme Court has responded. As was mentioned by Sara, we have had many petitions filed on the issue of fundamental rights. The response has been very, very unfortunate, and I would like to focus on that. What we see, and I also want to say that this is not a rupture to what has been happening in the country in the past. In fact, the pandemic moment comes at a time, and this is my opinion, it comes at a time when we already did see very serious fissures and schisms in Indian society and polity, and there was a contestation going on in India, for instance, around the Citizenship Amendment Act, where there was a challenge to a certain perspective and viewpoint that the government was advocating, and there was a citizens' protest and opposition to it. For many reasons, for the last few years, we have seen some institutions not being able to function either as robustly or effectively. And the pandemic comes at the backdrop of that, and the pandemic actually puts a very serious strain on democracy and gives an opportunity to the executive to actually use the occasion when there is, and there is bound to be, a genuine anxiety, alarm, concern, fear around a virus which we don't know enough of yet, and whether that is a moment when the executive can aggregate more power, centralize more authority, and ask citizens to cede rights, whether those of privacy, as were mentioned in the opening remarks, through the Arogya Setu app and otherwise, or through surveillance. And that's the backdrop in which I would like to locate what I'm saying. What we are seeing is that the executive decision making, and I would not like to call it governance or administration, because if the consequence of that decision making is, and that decision making can only be described benevolently as extremely arbitrary and unplanned, which has left lakhs and millions of working class people and poor people without home, without livelihood, and therefore compelled them to start walking back home, because every single mode of transport was till very recently completely shut down. The whole country was shut down. And why? Because there is a public health crisis. A public health crisis is not a threat to the state. It is not a condition of emergency. It is not a situation where the executive can acquire and control more power. If anything, it is a moment of conversation, consultation, and compassion from the state, of which we have seen very little. With millions walking back home in utter confusion and poverty. And when I say walking back home, they are walking across the country for thousands and thousands of miles. It is unimaginable how graphically the class divide of India has been etched out for everyone to see today. At that juncture, how does the state respond? The response of the executive has been punitive. It has been an over-reliance on a carceral and criminal law machinery. The ordinances that have been enacted have at each point been about criminalizing behavior. So if people are walking, stadiums have been converted into prisons, and police has been asked to throw people into stadiums and lock them in. Ordinances that have been passed in the name of protecting doctors, health workers, where there is a paucity of PPE. Those ordinances are redrawing the line on criminal law, overturning basic tenets, and assuming and creating presumption of culpable mental state, and prescribing extremely high penalties, both imprisonment as well as fines. One state, for instance, UP, has recently passed an ordinance that if anybody will intentionally afflict the contagion to somebody else, there will be a very high penalty, including imprisonment of 3 to 5 years or till life imprisonment. Clearly, these are open-ended offenses, description of offenses, which will be subject to arbitrary and capricious use. We also see that the only way in which the state is responding is through policing or through criminal law. So while everything else is under lockdown, it is the police arm of the state that is actually almost in an overdrive. The second thing I would like to point out is that at a time when there is no parliamentary oversight, because of no congregation, parliament is no longer in session, the executive is passing orders. The only forum that is available to us for any questioning or examining of executive orders then becomes the court. Very early on, when the courts were closed, virtual hearings were begun. To that extent, access to the legal system, while it is subject to the digital divide, and let us not imagine that technology creates equity. In fact, technology, if anything, further reinforces the inequity across classes and regions. Very early on, a petition was filed seeking redress for migrant workers, as well as payment of minimum wages for migrant workers. The state filed a status report on behalf of the Home Secretary of the Union of India, in which it was said that as of 11 a.m. today, this is 31st March 2020, the status report said, as of 11 a.m. today, there is no migrant worker walking on the roads of India. They have all been taken into shelter homes, provided food and shelter. The petitioners repeatedly asserted that this was not true. In fact, I don't know why we had to, it was actually visible to anybody who would look at the highways or in media reports or on television or on social media. You could see families walking with children. The court, nonetheless, deferred to the status report without asking a single interrogation of substantiation of what the status report said, and said the state is looking into it, they don't need to do anything. And petition after petition on behalf of agricultural workers, farm laborers, migrant workers met with exactly the same fate in the Supreme Court of India, which deferred to the wisdom of the executive and what can we do in these circumstances. We cannot run the country. I don't under any illusion that the country is to be run by the Supreme Court. That seriously is not the role of any court, and definitely not a constitutional court. But to accept what is written in a report, even though it belies everything that is known in the public domain, without even asking for a subsequent report to be filed, who has paid the price for this? are the poor and the working class, which is now walking back home, meeting with road accidents, dying of exhaustion. In what has perhaps given some semblance of sanity are orders passed by some high courts, the Madras High Court, the Nagpur bench of the Bombay High Court, the Karnataka High Court, the Madras High Court as recently as yesterday, in an order where you can hear the anguish, has said that tears come to one's eyes when you see the visuals of people walking, and has asked the center and state, what will you do? And how will you provide at each juncture? There must be some civic authorities which needs to provide them some relief, some mode of transport back. Due to the outcry created exclusively by civil society, which was, and public interest litigation was, received very, very caustic remarks from the state when activists went to the Supreme Court, that why are they raising such issues? I cannot think of a moment when public interest litigation by social activists would be more necessary in the life of Indian democracy. However, these courts have now asked questions. We wait to see how the executive will respond. Due to media publication, there has now been some transport initiated, that too at expenses which initially the migrant workers were to bear. Nobody knows what the truth is, as was said earlier. If any journalist will ask far too many probing questions, if there will be exposes done of what is happening and how what the state is saying, and the pronouncements made by the state are not substantiated by the ground reality, then there are measures being taken. Police is filing cases, and of course the most favored tool of sedition comes always to the rescue of the state and the police. I want to move on from there to looking at some other issues. We've also had, because now the state seems to have moved, and this seems to be a way the state functions. There are pronouncements made that this will be done. Whether it is done or actually does not materialize on the ground, for instance, shelter homes, helplines, whether they actually do materialize on the ground or not, there is no authority which can question, and the court seems reluctant to ask the pointed questions and ask for some proof of what it says. And then the executive moves to yet the next stage. So then came the intermittent stage of distracting people through the spectacle, whether it was showering flower petals by military helicopters on hospitals. These are places where health workers are asking for PPEs. As in Bangladesh, they've been told they will not speak to the public. Military bands were asked to go and play in hospitals to boost the morale of health workers. So we are in a time when the executive either has large pronouncements, and we are told that India is going to actually be the nation that will lead the world in the 21st century, or we are distracted through a spectacle of what the army and the military will do for the new corona warriors, and the language of war continues to populate the discourse. In the midst of all this, the labor laws are being dismantled because now the economy needs to be revived. So I'm told that that about a few hours ago, perhaps the UP government has been compelled to withdraw the ordinance. But what is very much on the table and is on the anvil is that the hard-fought 8-hour work limit and payment of overtime and maximum work hours, which are inscribed even by the ILO, is to be pushed, is to be let go. And without payment of overtime, workers are to be asked to work for 12 hours because they are now going to revive the economy, which across the world has taken a hit. Other trade unions, as well as other basic protections provided to labor, is being systematically dismantled in the name of rebuilding the economy at a time when it is the working class which is extremely impoverished in the last 2 months. I'll just quickly, because there are a lot of law students, so there is a lot of excitement in India over virtual courts and e-filing. And yesterday we actually had the Chief Justice of India and Justice Chandrachud, who heads the the Supreme Court of India, actually do a live demonstration. I myself have appeared in 2 virtual hearings before the Delhi High Court, sitting in my own office here, and it's been successful and we have achieved desired results. However, I really think we need to caution ourselves over getting unnecessarily carried away. I think technology can step in to provide an intermediate stage. I do see a lot of webinars, particularly hosted by corporate law offices, which are peddling virtual courts as something that will now create access to justice. And it's quite amusing to hear this phrase from corporate lawyers, and that haves and have-nots will have equal access to justice. Clearly, the life of the have-nots, which are the migrant workers, many institutions and personalities seem to be a little out of touch with it. The digital divide is not going to bridge the inequity in access to the legal system. I'm not even going to call it access to justice. I think we need to abandon that phrase once and for all. We should have virtual hearings. All hearings cannot be virtual. At a time when, and I'm talking particularly of Delhi just now, at a time when there is complete lockdown, what we do see is that under instructions from the Home Minister, the Delhi police is working very, very hard round the clock, picking up human rights defenders in some conspiracy that we are told they are investigating. We do not have access to those first information reports. Lawyers are unable to attend remand hearings. We do not, bails are becoming extremely difficult. So this moment is not changing the kind of tension that one always experiences for getting justice for human rights defenders. While there are high-powered committees now in every high court pursuant to the Supreme Court of India's directions to decongest prisoners, human rights defenders who by their own, even according to the police, have never used violence, but whose ideas may be antithetical to the present regime, are being arrested and sent to prison even during the pandemic, when prisons, and we already know that in Bombay, at least in 2 prisons, there have been instances of Covid-19, and the prison is a place where we know there can be very, very severe outbreak of pandemic, which would be, and these people, the courts must remember, are in prison and judicial custody, and therefore whatever happens to their well-being and health, the courts are exclusively responsible for. I think my time should be getting up, so I'm only going to conclude very quickly to say, I think this is a moment which is being used under the garb of the anxiety that all of us would carry of the pandemic to actually restrict civil liberties and freedoms. And for our own good, we are supposed to allow surveillance of our lives, although accountability and responsibility of the state, whether in terms of health or economy or jobs, seems to be completely absent, and questioning the state. Of course, the very useful device of anti-national is being deployed repeatedly. And I think we need to caution ourselves against the backsliding of democracy that is taking place at this juncture. And it's important to speak out now to ensure that all institutions are able to question, interrogate, whether it's the media or it is the courts. And if the courts are not performing their constitutional obligations, I think it would fall upon the citizens of the country to remind the court that they must ask pointed questions and demand explanations and answers from the executive.
Thank you very much, Vrindaji. Now it's my duty to invite Mr. Salman Raja. He received his legal education from Cambridge University London University and Harvard Law School. He practiced law in all kinds of courts like trial courts, provincial high courts, and the Supreme Court of Pakistan. He appeared in several landmark cases. In 1997, he was the person who achieved the Muslim women's right to marry without a male guardian's permission. It was a great achievement. In 1998, he led the challenge to the freezing of foreign currency accounts in Pakistan, following the nuclear tests. The challenge from him to National Reconciliation Ordinance of 2007 was significant. If it was on behalf of Dr. Madabhushi, whereby a large number of politicians have been granted quashment of sentences and proceedings against them, including late Benazir Bhutto. Mr. Raja has taught at various leading law schools and universities from time to time. I welcome you, Mr. Salman Raja. Over to you.
Thank you, sir. And, I really enjoyed the two presentations made by Sarah and Vrinda. And really, let me try and place Pakistan in the context of what we've heard about the other countries in South Asia. What has happened in Pakistan is, in some sense, some degrees different from what has happened in Bangladesh and India to the pair. What has happened here is that from the very beginning, we have a prime minister who's been lukewarm about lockdowns and about really moving too far away from normalcy. So it's been kind of a half-hearted effort. We had about 2 weeks of fairly strict lockdown from 25th of March onwards. But throughout that period also, the Prime Minister would come on TV and say that he was very unhappy, that he was unhappy about the poor people being rendered jobless, the daily wage workers, and so on. So we've throughout had this atmosphere here in Pakistan, whereby the virus is being looked at as some kind of a hyped up event. And for whatever reason, in South Asia, we know that the spread of the virus, or at least its virulence, has not been what it has been elsewhere in Europe and in the US. So that somehow has worked to the Prime Minister's advantage. And over the last week or so, we've had a very significant relaxation of the lockdown. At the start of the month of Ramzan, mosques were allowed to hold congregations, the evening prayers were allowed, and so on. So now we see the shops are opening up all across the country, even though the Sindh province, which is ruled by the People's Party, Benazir Bhutto, the late Benazir Bhutto's party, they're resisting. But even there, because there is this national kind of mood being created by the Prime Minister and the ruling party in the center, it's becoming harder and harder to maintain the lockdown that the provincial government would want to maintain. So we've throughout had this kind of an ambiguity about how normal things are and how abnormal things are. But having said that, it is clear that a large number of people have lost their livelihood. The daily wage workers have not been really catered for, even though there has been some kind of a cash transfer, a one-time cash transfer of about 12,000 rupees to a fairly large number of households. But that clearly is not enough. But what is then also coming into play, I think, is the general atmosphere that existed in the country before Corona erupted. And this was really an atmosphere in which if you like, the establishment, as we euphemistically call our ruling powers that be, have been imposing a kind of discipline over the country in the last 2-3 years. And the idea was that somehow the anti-establishment democracy that in his later months Nawaz Sharif had come to represent had gone too far. And things had been kind of brought back, as it were, into the normal discipline that our establishment craves of the country. So we've had a stifling of the press very clearly. We have had the electronic media fall in line. So the opportunity to really raise dissent and critique had been, muzzled even before the virus erupted. And what we see over time, over the last 2 or 3 months of the period of the virus, that we've not had a harsh critique of what the government has been doing. So yes, there was hardship over the 2-3 weeks, and we had a fairly strict lockdown. But really, whatever happened by way of protest was underplayed in the media. There was protest by doctors, for instance, in Quetta in the Balochistan province. There was some protest even in Lahore, where I live and work primarily, by doctors complaining that they were not being provided proper protective gear. But that again was not really carried in the media, and one young doctors organization that did go to the Lahore High Court was in fact reprimanded by the High Court for appearing subversive at a time of national crisis. And not only was their petition dismissed, heavy costs were imposed on them for having taken a matter that was administrative in nature to the court. So that is the general atmosphere that we worked through. And over this time, again, there's not been a slew of ordinances. We've had sessions of Parliament. The Senate was in session till yesterday. It met for about 4 days after a fairly long gap. And some opposition leaders made speeches critiquing the government's ambiguity and the uncertainty of approach that the Prime Minister had created, and this binary created between lives and livelihood, which really is something that lies at the heart of what has been happening here. But having said that, things still remain more or less in the government's control. The Supreme Court tried to intervene once, took a suo motu notice of what had happened by way of botched quarantine in Taftan with pilgrims returning from Iran. And the person in charge, the advisor on health to the Prime Minister, was severely reprimanded, and it seemed that they were going to pass some strictures and maybe even remove him. But that did not go down too well in the media, because we've had this period of, if you like, judicial activism gone astray the last few years. The previous Chief Justice, whose tenure ended in January 2019, had really become a roving court, visiting hospitals and schools and colleges and passing orders on the spot. Now, having lived through that experience, the present appetite of both lawyers and I think the media for judicial activism is low. And that again helps, in a sense, the government, because the judiciary, having taken what seems to be a step in the direction of examining government effort, has gone back, and that effort is no longer being seriously, if you like, supervised or challenged or examined by the courts. Now, staying with the courts, the Islamabad High Court passed an order about 3 weeks ago, which said that all prisons in the jurisdiction of the Islamabad High Court should look into the cases of both under trial prisoners and convicted prisoners, and bails should be liberally granted, given that jails are likely to be incubation centers for the spread of the disease. And the provincial governments were asked to use their powers under the Criminal Procedure Code, Section 401, to release prisoners, keeping in view the health situation or the threat to health. That matter was taken up by the Supreme Court, and the order passed by the Islamabad High Court was struck down. And the Supreme Court passed its own order saying that 401 of the Criminal Procedure Code is not available in this situation to the provincial governments for releasing prisoners. However, the cases of under trial prisoners, prisoners who've not been convicted yet may be looked into sympathetically for offences that carry a sentence of less than 10 years. So that is where we are really in terms of the court situation. The High Courts and the Supreme Court have formally continued to function. There have always been some benches of the Supreme Court or of the High Court in session, but they've really only heard matters that they've considered urgent. Normal hearings are not happening. It is, in theory, possible to move a public interest petition or a human rights petition and have the court hear it if it's convinced that it's a matter that requires looking into quickly. And that has happened. For instance, the government moved a petition for permission to hold elections in Gilgit-Baltistan and to amend the existing framework for the holding of elections in Gilgit-Baltistan. That was taken up fairly quickly by the Supreme Court. And the order that the federal government wanted was granted. The trial courts have also formally been functioning, again in reduced numbers, but they've really only heard bail petitions and nothing much else. In terms of domestic violence and issues that concern women, matters like custody, again, normal hearings are not happening. Even criminal complaints are not being entertained by the courts. The police turns women away in routine, saying that they have other more serious things to look into, like the policing of the bazaars and the roads, where they have imposed discipline when the government has so desired that discipline to be imposed. But it's really, I would say, more a pretext for taking prolonged furlough, if you like, and not being available in the police stations to entertain people who come up with their grievances. So that is a situation of concern. But we still are not sure how long this situation is going to continue. The Prime Minister comes on TV almost every day to say that, look, we have to get used to this. This is now going to be the new norm going forward. And we need to return to normal life. Now, through all this, we've been told that the telecom companies have been, in a sense, co-opted by the state, by the intelligence agencies, to carry out track and trace operations. Now, again, that remains shrouded in mystery. No legislation as such was passed to do this. And this seems to be an event or an exercise taken pursuant to executive orders being issued by the cabinet. And that is a question that was already before the courts. What is the extent of the inherent executive authority of the government? And that issue, while it was being debated quite seriously before the courts, has now gone into the background. And the government is using its so-called inherent executive authority to do all kinds of things during this period when normal legislation is not taking place, even though, as I said, the Senate at least has been in session, but not so much the National Assembly. The National Assembly had a session as well, but there's really been no occasion to do serious legislative work. So how do I sum up the whole situation? I would say that we've had a kind of a lukewarm departure from normalcy. The government has kind of tried to appear concerned and worried about livelihoods. We've not had the kind of mass migration that India has seen of workers returning to their villages. Why that has not happened is something that I really can't say at the moment, because inter-district transport was stopped fairly early on. It's now resuming, but we did not see long lines of migrants or internal movement of workers back to their villages. This may be because we had a fairly vigorous income support program underway even before the virus. It's called the Benazir Income Support Program and renamed by this government as the Ehsas program, which had tracked down, listed about 35-40 million poor households for direct cash transfers. So how much of that is responsible for maintaining some semblance of sustenance for the poorer households? Again, the figures are not out yet, and what has happened will become clearer in time. So we've not had that kind of a crisis yet. So we're braced for impact. The way Ramzan is proceeding, what is likely to happen around Eid may lead to a major spike in infections in June. And if that happens, then all bets are off where the disease may go and what the fatalities might then be. But since we've not had that kind of crisis so far, the government is kind of riding its luck. And I'll agree with Virinda that there is a class divide that has become clearer through this period between those who can access the judicial system through high tech, whose concerns are of a particular nature, competition law, tax tribunals, and these sorts of bodies have been able to function online, but not so much the family courts and courts that deal with ordinary cases of violence, including domestic violence. So what was already wrong with the society, or the inequity that existed in society, clearly has become more apparent during this period. So I think I'll stop with that and maybe take questions later on. Thank you.
Thank you very much, Mr. Salman Raja, for the ground realities of Pakistan, as evident from your talk, how the COVID-19 is impacting justice system, and how a limited functioning of courts is again impacting the life of the people. Now we have two more speakers, two more presentations. Now I invite Ms. Tyagi Ruwan Patirana. Excuse me if my spelling is wrong, correct me. She is a Sri Lanka researcher. She was an eminent personality in Amnesty International's regional office of Colombo. She was with International Commission of Jurists. She was a consultant at the Consultation Task Force on Reconciliation Mechanisms. She's a researcher with the Center for Policy Alternatives. Tyagi was working on transitional justice, accountability, enforced disappearances, reparations, conflict-related sexual violence, and anti-Muslim violence, counter-terror law, and the shrinking space for dissent in Sri Lanka. I request Tyagi ji to present the situation in Sri Lanka. Welcome.
Hi, thank you. I'll quickly take you through in these 10 minutes what we've been seeing in Sri Lanka, and I think it's a good thing that, I mean, the Amnesty office is based in Colombo, so actually most of my colleagues from the region are able to see what's happening in Sri Lanka, which in a sense is unique, but sometimes it's not as bad as it could be in other countries. So at the moment, Sri Lanka has about 935 coronavirus cases. Out of that, about 520 of them have recovered, and that's more than half, so that's significant. There have been so far 9 deaths, and there are allegations of other deaths as well, which may or may not be linked to the coronavirus, but at the moment the official figure is at 9. But of course, as with most of the countries in the region as well, we also have big issues around testing and who's eligible for testing and those testing numbers. So the government itself has been putting out numbers as of late, and also setting itself new targets per day. So Sri Lanka actually went on partial lockdown exactly 2 months ago. That was on 16th of March, when the government asked people to start working from home. And then it actually went on a lockdown, and I'm saying lockdown because the term curfew is also an issue, because there are claims that the curfew isn't legal. It hasn't been passed through the public security ordinance as it usually would be. So whether this is a legal curfew itself is an issue. So like I said, so since the 20th, we went on lockdown. So now it's almost been 2 months. And most of the courts in the country stopped working around this time. So it's been now 2 months since the court stopped working. Magistrates have managed to hear bail matters because this is how it also works over the weekend. So people are produced in front of the magistrate at their houses. But the other courts had stopped. And the support thankfully started working this Monday, this week, on the 11th of May. So that's promising. I want to touch on a few human rights issues that are cropped up during this time. One major issue, which is also now before the Supreme Court, date hasn't been set for these fundamental rights petitions, but there's an issue around burials. So the WHO guidelines allow for burials of persons who have fallen victim to the coronavirus, but the Sri Lankan regulations have been changed almost overnight to prevent people from being buried, so that there are only mandatory cremations. So this has obviously significant implications on the Muslim community as well as some in the Catholic community, who don't cremate bodies. And this, of course, you have to understand that this is happening in a context of heightened Islamophobia. We've seen Islamophobia in Sri Lanka for a very long time, perhaps not to the extent that you see in India, but it's very much an issue. And because of context, the present situation where Muslims cannot be buried and is being forced to cremate is a huge issue on the freedom of religious belief. So there have been now a number of fundamental rights applications filed, including from the Catholic community about this. So we're waiting for these to be heard, but of course the damage is already done. The community already feels more marginalized than it did before. On freedom of expression, we don't have an exact figure yet, but at last count, we had about 17 people who were arrested for making statements online. So on the 1st of April, the acting IGP, who's the Inspector General of Police, issued a media notice saying that strict legal action would be taken against people who criticize government officials. And so this was kind of loosely worded. It didn't say prevent government officials from COVID response, but it said criticize. So that itself is a problem, because in a context where the government itself hasn't passed restrictions through law saying what the limitations on the freedom of expression are, this becomes a problem, because you have to do the tests of necessity about all the checks and balances that usually come with it are not afforded to this. And so in this context, you should also notice that some of these arrests are for different things. So they are also blurring this line between spreading false news and also criticizing government officials. So we don't exactly know who and how many have been arrested for which and under which laws they're being held to account. So there's that going on. At the same time, I want to also talk about the PPE for frontline workers like doctors, nurses, public health inspectors, including also police and military, because they have been on the front lines, and more than half of Sri Lanka's positive cases are now of the military who have been on the front lines. Actually, doctors and nurses, some of them, the General Medics Association went on strike saying that they haven't got the necessary protection equipment to do the work they need to do. At the same time, we're also hearing about cases of police brutality where they're treating people who are being arrested for curfew violations, being treated in a degrading way. We are also hearing about cases of domestic violence and child cruelty as well. And at the same time, there's another key case that we've been following of Hijaz Hizbullah. He's a lawyer, a very senior lawyer of the Supreme Court, who has been arrested, and they say it's in connection to the Easter bombings of April last year. So it's taken them to arrest this guy if there is any depth to the charges. And he's been arrested, and they're looking to charge him, or he's being detained under the Prevention of Terrorism Act, which has been a huge issue in Sri Lanka, and the international community also has asked for the act to be repealed and replaced. He has not been given his due process rights. He's not been informed of the charges, although the police has been talking about the suspected charges on media. He hasn't been formally told. He hasn't got unrestricted access to counsel or his family. So, and now it's been more than a month since he's been arrested, and fundamental rights petitions and habeas corpus applications have been filed on that. I know some of the other panelists touched on this as well, but the prisoners issue is something that we were grappling with as well, and very early on. There were a couple, I want to say a couple of hundred prisoners who were released after this because civil society and a committee all wrote to government about releasing certain prisoners, like either small-time offenders or people who just haven't been able to meet bail conditions, although who have been granted bail. So some of them have been released, which is welcome news. At the same time, though, I want to also say how during this pandemic, the president of Sri Lanka used his executive powers to grant a presidential pardon to somebody, a sergeant of the Sri Lanka army, who was convicted of killing 8 Tamil IDPs during the war. So this case of Sergeant Sunil Ratnayaka, and we've released some statements on this as well. It's a well-known case. And there were rumors from the time the new president was brought into power that he would be released, because it was also an election pledge that some of the military accused who are behind bars will be released after the new president comes to power. And so this Sergeant Ratnayaka is the first of the lot to be released, and that's something we're watching as well, because it's very worrying for the rights of the victims whose rights to justice and accountability have been hampered through this executive pardon. And just to say also that this conviction was something, it's a rare case of justice, especially for Tamil civilians, where the perpetrator is a Sri Lankan army official. And both the High Court and the Supreme Court have upheld the the High Court's conviction was upheld by the Supreme Court. So that's something worrying as well. And at the same time, the rights of workers, including the free trade zone workers, the daily wage earners, their situation is also quite dire, and the government has to step up to look into their needs. So all of this is kind of happening in a strange situation. That's why I mentioned earlier that the Sri Lankan situation is a bit unique, because in a democracy like Sri Lanka, there are 3 arms of government that are supposed to sort of act as a check on each other. And right now, Sri Lanka is in a unique position because on the 2nd of March, the president dissolved the parliament. So right now, we are in a situation where we don't have a parliament, nor do we have a effectively operating court system. So what is happening now is executive overreach over a number of human rights issues, which have no ways of getting any remedial action. So since the parliament was dissolved on the 2nd of March, the president hasn't revoked that gazette that dissolved the parliament, which would bring parliament back in life. And why is this important? It's important because at a time like this, if existing laws aren't sufficient to deal with the pandemic, there should be new laws that could be passed, or there could be the state of emergency that has to be reviewed by Parliament. If it was issued, the state of emergency has ingrained checks and balances through the Constitution, so you have to put it through Parliament every 30 days. And so this is also one of the reasons maybe the emergency regulations weren't passed through the Public Security Ordinance, because there is no Parliament to sit and review this. And also, the Parliament's function is very important also because it's a time where there's budgetary implications on Sri Lanka's economy, and Parliament has oversight over public finances. And right now, with no Parliament to oversee these things, we're in a bit of a fix where we can't allocate funds effectively because the budget has effectively expired. And then also the judiciary in this situation then becomes that much more important, because cases on executive overreach, fundamental rights applications, habeas corpus applications have to be heard, but all these rights applications have not been taken up. So for example, issues on prisoners' rights, on Sunil Ratnayaka's release, about the freedom of religious belief of the victims who are affected, presidential pardons, all of that is now sitting in backlog, and in a system which is already overburdened and crowded, this is going to create more issues in the long run. So the Supreme Court, as I said, has started hearing cases. So we know, for example, cases that have been filed on the fact that now the elections, the general elections, which were set for a period So how it works is that in Sri Lanka, you have to have elections within 3 months of dissolving the parliament. And now, because of the coronavirus pandemic, the Elections Commission has postponed the elections till, I believe it's June 20th. And that's a period of over 3 months. So now there have been petitions filed about this, and the Supreme Court, thankfully, has set dates to hear this next week, and that's welcome. So like that, I believe we have to find ways to hear urgent cases and to make sure that, the entire justice system, parliamentary system, all arms of government don't count as preaching court. I know a lot of panelists also touched on this as well about virtual courts and how, we can maybe look at creative technological solutions to this issue. But like what others mentioned, in Sri Lanka also, they haven't stepped up to the challenge. Maybe I think other countries have more than Sri Lanka. Email submissions, virtual courts, etc., so that courtrooms aren't packed like they usually are. But like most panelists mentioned, we are also talking about access to justice and the structural issues that get exacerbated during this time of COVID. And so a very paper-based system can't, smoothly transition into a completely virtual online system and guarantee the same access it had before over a couple of days. So I think it's also time for the Supreme Court to start thinking more creatively about how it can guarantee access to make sure that everybody has equitable access to justice, and make sure that it finds ways to hear these very urgent cases, especially on human rights violations while there are deaths going on at the moment, so that more human rights violations can be prevented in the future. Thank you.
Thank you, Ms. Tyagi, for your status report of Sri Lanka. Now I request Ms. Maja Daruwala, the Senior Advisor to Commonwealth Human Rights Initiative and Tata Trust. She's a barrister by training. She served at the Supreme Court before taking up as a program officer for South Asia at the Ford Foundation. She was director of CHRI for more than 20 years. Her interests lie particularly in the area of systemic reforms. She has concentrated her energies on issues of accountability, particularly promoting police reform and the right to education. I request her to present the India Justice Report.
Yeah. So what the India Justice Report does, it ranks large and small Indian states by each one's capacity to deliver to the mandate that they have. And the other thing that it does is that it assesses the intention to improve. And all this it does through by taking the statistics that are published by the state and collating them, aggregating them, and disaggregating them. What it does, so I just want to repeat, it measures only the capacity of the state. You heard just Professor Acharyalu saying that my interest was in systems, and so this is about systems. It's completely different from the realities that you talked about. This is the reality of a system that is supposed to be delivering the delivery of justice. We struggled a lot to find out whether we were talking about the courts, or whether we were talking about the police, or whether we were talking about justice. Because justice is much more than merely what the structure of the courts is or the capacity. But what it does not do, this report does not do, it does not measure outcomes. It does not estimate the quality of the service provided or the public satisfaction, or make judgments based on any extraneous indicators. So what did we measure? In this is a first of its kind report, and it's an all India report. So it was a big undertaking, which took about 18 months and had collaborators, some of whom are sitting here like CHRI, but we had 6 or 7 collaborators, all of whom were specialists in their own areas. And what did we measure? We measured the subsystems we looked at the police, the prisons, the judiciary, the legal aid. We didn't have enough data or enough bandwidth, frankly, to look at things like prosecution and forensics and oversight, and we would love to do that at another time. In looking at these systems, we looked at their budgets, their infrastructure, their human resources, the diversity, because we thought that diversity is a really important factor to factor in the delivery of justice, workload, and most importantly, we looked at trends. We looked at trends because we wanted to estimate in figures what is the intention of the state. Is the state trying to improve itself? Is it stagnant? Is it going backwards? Is it making any effort? And so we looked at trends in all of these. When we were looking to find the statistics, there were lots and lots of challenges. When we were looking at how to make a fair comparison, we found that though there were over 700 or 800 small indicators which we could have collated. But if we had done that, we would not have got to a comparative. So where we could find an evenness among the states and where we could find a comparative mashing of data, we finally got to about 78 derived indicators. So in the beginning, it was a iterative process of meeting again and again to refine what we wanted to say. We had really good advisors and an amazing, I mean, if somebody wants, and honestly, I say this with no modesty or with a great deal of modesty, whichever you like, because Sanjoy is here and he was part of it. The amount of collaboration we got, the amount of goodwill we got, the amount of no quarreling or angularities we got was a real lesson in how to collaborate as CSOs. The challenges were, of course, information, the availability of data, consistency, collecting the raw data, and then scoring. Finally, we decided that whatever we had collated and we had mashed together, we would not put in any weightage. All indicators would be from 1 to 10, with 10 being the best state and 1 being the worst. The other thing we didn't want to do was to measure anything against a CSO standard. So we took the standard that the state had set itself. If the state had said, if there was a hard law indicator, like you have with reservations for scheduled caste and scheduled tribes, then we had that as a benchmark. If you had a policy indicator like 33% women in the police, then we took that. If we had an indicator that everybody had generally accepted as being the way to go, like the model prison bill, then we took that as the benchmark. And where there was absolutely no benchmark, for instance, how much of the population should be served by a police station, we took a comparator between urban policing and rural policing. You can go to the next slide, Venkat. In order to measure like with like, we took 18 large states and 7 small size states and clustered them so that we ranked them against each other, and it was not unfair in that way. So the 18 large states were the states that had more than 10 million population. We didn't rank what in India is called the union territories because they are governed by the center, and there's no comparison between the union territories. Were not able to be compared because Delhi is a size of a large state, but Daman and Diu are tiny little states. So we gave all the data, but we didn't rank them. And 4 states we left out in the Northeast and in J&K because they were conflict states, states that have been in conflict for a long time, and their justice systems have become skewed and the way they deliver has become skewed because of the unusual legislation which is over there, the Armed Forces Special Powers Act. But I just wanted to point out that the three large states that came on top were Maharashtra, Kerala, and Tamil Nadu. And at the bottom was UP, Bihar, and Jharkhand. In the small states, there were only 7 small states. The top state was Goa, and tiny Tripura was the small state. But the interesting thing here is the figures near the numbers. No state on a scale of 1 to 10 reached even 6. And the smallest, the poorest in rank, which was UP, did not even reach 4. Now, UP is a state with 200 million people. So if you're looking at the delivery of justice as a whole in India, you really have to wonder that in our 75th year, or whatever the year is that we have got independence, we have the best state, Maharashtra, not even reaching 6. The other interesting thing when you're looking at statistics is that Maharashtra, in all of the in police, prisons, legal aid, and judiciary, not in any one of them did they come first. Kerala came first in 2 of them, and within the top 5 in all of them. But unfortunately, the only one it missed out on was in policing, where it came 13th or so because there were very, very few women in its police force. So I just wanted to press this point that everybody knows that Kerala's police force is a cut above the others. So statistics only tell you half the story. And one has to be careful when you're looking at reports like these. The report should be a baseline for other people's research. But it can go, we had hoped that it would go on year by year so that there would be a competitiveness within the states. But it is not to be used as gospel for what the reality on the ground is. So what were the findings? And I think this is important also for all of our cousins and all from South Asia, because the pathologies that we found are known to the public, but are not, have gone unaddressed for such a long time. We found that in all the pillars, no one came up to scratch. Every state had over 20% or 20% vacancies. In some areas like police, like prisons, I beg your pardon, where you have social workers, etc. In some states, it ran to 50%, 60%. So what does that say about legislation? What does that say about benchmarks? What does that say about finances or a caring system? Quite apart. And what does that say about accountability? Now, when I say that there were vacancies of 20% going up to 50%, 60%, I'm talking about sanction strength. That is to say, what has been written down in policy will be the sanction strength. Supposing the sanction strength is 10 judges or 20 doctors. We don't know whether the 20 doctors and the 10 judges are actually what is required. We merely know that it was sanctioned so many years ago. When the sanction strength was changed, etc., that has to be interrogated. And we hope that this kind of reporting will create that kind of interrogation. So please change. As I said, there are high vacancies. Then we looked at, I don't know if your slides have changed, but I am moving on to looking at diversity. Diversity data was available for some stuff like scheduled castes, sometimes scheduled tribes, but not in all ranks and not against all the pillars. So it was very difficult to make that comparison across all pillars and to see how well integrated or how well complied with the notion of diversity in a democracy was being complied with. But we found interesting statistics about women in certain areas. Where we did find them, we found that these are 2017 figures. They have improved since then, but when we looked at them, if you look at it average to all across Indian states, you will find that they are no more than 7%. Where those 7% are, that needs to be interrogated. They're not always in police stations. They're not always in rural areas. So the deployment of policing of diversity, of various kinds of diversity, is something that definitely has to be looked at, because it so deeply affects the ability of women to access first responders and also STSCs, poor, the urban, the rural. All of these are affected by the lack of diversity. Similarly, in prisons, we found that there were only 10%. Wherever we found them, we found that in the lower judiciary, there is something like 28, 29% of women in the lower judiciary. As soon as you hit the high echelons, whether it is officer cadre of the police or prisons, or it is the judiciary, the High Court, the Supreme Court, it goes down sharply to single figures, and you lose women everywhere. If you could leave that, horseshoe one on, that would be helpful. And if you can all see it, that would be very nice. Can you all see it?
Yes, yes.
Oh, grand. Okay. So the last thing I wanted to say was that we hope that this will be an iterative process, year on year, maybe every 18 months or so, because that's when the data comes out. And we believe, we showed it to the policymakers, the Niti Aayog, which is one of the most apex policymakers, and they were really very encouraging of us. But unfortunately, all the advocacy and the dissemination around this interesting report has been cut short by the COVID, but it has its uses. We wanted it very much to be used by policymakers, as I have said, by the bureaucrats, by the media, by academics as a baseline, because the one thing you can question, you can't question, I don't think you can question the methodology. I don't think you can question the figures, because they are government figures. But what you can question is how data is collected and how it is crunched and how it is presented by the government. For instance, you will not find any longer the data about religious diversity. It has just gone off the picture. It's just gone off the board completely. So where are the Muslims? Where are the Christians? Where are the Parsis? Where are the Jains? We don't know. So, and is the data validified when it comes from the ground? It certainly is not consistent across departments, let alone across pillars. The last user that I do want to talk about is civil society, because I'm basically talking to you guys today, which are academics and civil society. And I want to say that nothing would show me the success of this kind of work if it turned into a localized effort where district level, state level and district level civil society was looking at the figures that are available for their districts and replicating this kind of data so that it can hold the mechanisms that are tasked with the delivery of justice to advocate for better quality. The system itself is unable to deliver because of the structural pathologies. Those structural pathologies have lived for far too long. And it's very interesting, again, when we looked at the trends, we saw that some of the states that are doing better are not increasing or not going forward as much as they should. But a state like Bihar, which is low on valuations of ranking, is making an effort. We this time ranked all of the parameters on a scale of 1 to 10 and then gave 1 mark. Many people have argued that there should have been weightage. But since it was the first report, we felt that we could not give it weightage. We wanted it to be very, very credible and lean a little bit towards persuading people that even when we look at the lowest common denominators, there is much reason to improve in a sort of federal competitiveness, because we wanted to pull them into the rather than create opposing camps, to bring them into to bring them into the conversation so that altogether we could ensure that these changes are made. Thank you.
Yeah. Thank you, Madhurwala. I request Mr. Sanjay Hajarika to initiate the discussion with your observations.
Well, after a remarkable set of presentations, Professor Chair, how much time do we have? I think we are running behind time, so I have a bunch of points. So I just want to I'll just stick to 4 or 5 because I see there are 17 or 18 questions. I think one of the things that came out, and I was listening very carefully to what Maya was saying, and this very important point towards the end, the system is unable to deliver because of a structural pathology. And I think that is really at the heart of some of the problems we are facing. And I think across the board, what we have heard is the arbitrariness, to use Vrinda's word, capriciousness of the state. I mean, here we are in 2020 dealing with a disease that nobody knows how to tackle with a 19th century law. I mean, that just sums it up. And the people who need support the most and help the most, they remain, as always, the most vulnerable and the ones who don't have access to rights. So I was thinking about what we are calling the migrants who are walking home. Anybody who's seen those stories, been involved in trying to help, cannot be but moved, if not to tears, but deeply pained by what people have gone through, millions of people. And I was telling Professor Acharya that the migrants' rights move with them. They end where they are stopped. And then it just finishes because they have no rights. The state takes over, arbitrariness and impunity takes over. And whether they live or die, there is no empathy from the top which has been expressed, except a whole bunch of rules which are changed from time to time. And I'm thinking about, how do we really mobilize access justice or even enable people to think about accessing justice, forget about accessing justice. How much technology, what do we need in terms of technology to make it really robust, to make the platforms robust, as Vrinda was talking about, whether it's one-on-one conversations with the courts, arguments or whatever, everybody's experimented, because this is the way we are going to live our lives for some time to come. I think this situation is not going to go away, perhaps ever in our lifetime. We'll have to live with this crisis. So that was one thing. Then I think the other point that Vrinda and others have made is the crisis of surveillance. The inability of people to protect themselves is one thing, but the way in which the state has intruded into all our lives. Here we are sitting in our rooms trying to have a conversation with each other, and the world outside has changed, and we don't know how much it has changed. So I think it is the state which has taken over so many powers, and that impedes whatever access that you seek to give justice to them. Now I will end with 2 points, because there was reference to it, I think one by Vrinda and I think by one of the panelists. On freedom of expression, we don't have freedom of movement, we don't have freedom of assembly. On freedom of expression, again, a century-old law is being rolled out to tackle journalists and others who are speaking out or writing or broadcasting. And we have examples of that even from yesterday in this country. In Bangladesh, you have the Digital Security Act, which is being used to harm the independence and freedom of media. The last point, I have other points, but I would just close with one thought, is the arbitrariness and caprice that we spoke of earlier. CHR has issued these guidelines, both proposed guidelines to the police and prisons on release of prisoners, on how police need to conduct themselves during this crackdown by putting people first and not the danda, dialogue, not the danda. But I think one of the critical situations is that we are, people are unaware of the scale of the problem. For instance, we are talking about migration. The migration figure for 2011 in this country, in India, was 450 million. That's 1/3 of the population. That's 2011. That's 9-year-old data. That means the figure will have gone up, as Venkat was saying the other day. Not all of these are labor. These are people who are moving for marriage, for other things. So the scale of the problem is mind-boggling. So whatever we do, and in this time when there's a crisis with the courts, really, they're unable to deal with the situation. Many district courts are not functioning. There is no way that people can even approach anyone for help because the police are not even registering cases of domestic violence. And the pandemics that are sweeping the country have swept it for many years before this one. And that's domestic violence and child abuse, apart from anything else. And in this whole thing, those are being put on the back burner, along with the other health pandemics like the immunization and so on, which are absolutely critical to the future of our lives in this country. The whole issue of fake news and Islamophobia was referred to by our colleague from Sri Lanka, and I think that is a substantial issue that has not been addressed. And I would like to hear from the panelists at least some reflections on these things, because we can't obviously deal with all of them, but a few thoughts would be very welcome. I'll close here. Thank you.
I would like to hand over the floor to Professor Acharyulu to bring the event to close by doing a formal vote of thanks. Over to you, sir.
Now, after hearing the panelists and understanding the ground realities of in 4 of the South Asian countries, I'm really looking at only the challenges, and nowhere any of visibility, any possibility or hope of a solution. Access to justice became so invisible or so minimal. So I don't know whether what I am teaching in the classroom and what I am talking about constitutional law and my students here listening to all of you will find huge difference. Perhaps they think that I am not speaking truthfully because of the situation. So it's really unfortunate. The least expression I can make, very unfortunate. The right to live is affected because we don't have internet. That is right to life. Right to life is a basic feature. That can be affected, and we are not listening to the voices. And one more serious problem I noticed from today's webinar is, if you develop an alternative technology, alternative methods in the form of technology and hand it over to authorities, a simple switch off will be switching off of the entire thing, and you will not have any access at all. One advocate was telling me from Chennai that he was representing a case against a stay order issued by local high court, and before he opened his mouth, because another council on a similar petition argued in a similar way. The Supreme Court, I don't know whether it is IT wing or any other authority, no, it's over, we heard you, and stay is vacated. So that kind of an order, he says that when you don't hear me, what is the use of technology? So even in the part hearing or partial hearing that is going on in Indian judiciary, even in that, it is not the question of technology, but it is basically a question of attitude. Are we listening to, are you hearing the other side? Principles of natural justice, I'll go much beyond the constitutional law. Just now, some speaker was talking, I think you were talking about whether the constitution is there. That is the situation we are in. Yeah. So my problem is, can we look at video conferencing as a partial substitute at least? And if so, whether this video conferencing, through video conferencing the hearing, will it stand the test of openness, public hearing, which we were talking about since ages? And that is the reason for the transparency. That is the reason, that is the scope for the transparency. I know that entire people cannot sit in a courtroom. Courtroom is also regulated and visitors are limited. But how do you ensure the public hearing if it is done by video conferencing? And you are not doing it fully, you are not doing it all with the lower courts. So whether it is lockdown of judiciary also. When judiciary is locked down, what about the violations of human rights? On one hand, you are talking about decongesting the prisons, and on the other, you are sending the people to prison. And on some kind of the reasons like freedom of criticism is absent, scope for dissent is reducing, and all these things are posing a very, very serious questions of general unconstitutional activities. And I don't know whether we should call it constitutional governance. Constitution and governance, both are seriously affected by the pandemic. Not much by the pandemic, but a lot by the general attitude. Now what I see is, by systematically, I take the expression of Mayaji, systemic reforms. Where is the system? It's only Parliament was the hope for making good legislation. So it is not functional because of not in assembly, not being in assembly. Then the courts, 90% of them are not working because of pandemic. And we totally depend on executive, and whatever they say, whatever they do, whatever police say in the street, that is what is going to be the law. So in these situations, the crisis alone, challenges alone are coloring. And I think my students are now better, they understood the dynamics of the theoretical constitution that we discussed in the classroom, what is happening. And that itself is an education. I hope this will help them to understand more the real situation. Now, I would like to use this opportunity to thank the CHRA for effectively organizing it and coordinating. I thank Mr. Venkatesh first of all, and I acknowledge the vibrant presence of all the panelists who really made this seminar very purposeful, very useful, very effective to understand the situation around. And I also thank Mrs. Sanjay Hajarika Maya for joining us. I thank Vrinda, I thank Miss Sara, Mr. Salman Raja, and Ms. Tyagi for being with us for so much of time. And I really, we cannot do this without the cooperation and support of technical team of Bennett University, under leadership of Sanjeev and Gopal, Swati, and my faculty colleagues, my dear students who joined the webinar and made it very successful. I thank one and all. Thank you. I wish you all the best. I hope things will improve, systems will come in place, and people will question the absence of system, and they bring the constitutionalism back to working. Thank you so much.